before we even get into the hearing, understand the setup. This is not just another routine Senate exchange. This is Republican senators framing Arctic Frost as a major political accountability scandal, tying together the DOJ, federal investigators, state prosecutors, Trump-related cases, and even questions about Congress and the Supreme Court. The big tension here is simple. Was this legitimate law enforcement, or was it political power being used against political opponents? Watch closely, because every answer either raises the temperature or opens another door.
So this was a coordinated, organized operation by the Biden White House, the Biden Justice Department, and the Democrat Party to try to destroy their political opposition because they were terrified that the voters would do what they did, which is in November 2024, re-elect President Donald Trump.
At a Senate Judiciary Committee hearing on Arctic Frost, Republican senators went on the offensive over the DOJ's investigation into Trump and other GOP figures. Watch Senators Cruz, Hawley, and Britt press witnesses on alleged political targeting. Here are the three most explosive moments.
Mr. Chairman, in the last hearing, we proved that Arctic Frost was no rogue operation. It was authorized at the highest level of the Biden Justice Department.
This opening is doing something very deliberate. And Senator Cruz is not just asking about paperwork or procedure, he is building a chain of responsibility. First, who approved it? Second, who coordinated it? Third, who benefited? That is classic hearing room strategy. Turn a complicated investigation into three simple questions viewers can follow. Whether you agree with his framing or not, politically, this is effective because it gives the audience a map before the evidence is introduced.
Today, we're asking the next question. Who coordinated it? Who profited from it? And who paid the price? Professor Epstein, on April 4th, 2022, Attorney General Merrick Garland, Deputy Attorney General Lisa Monaco, and FBI Director Christopher Wray personally signed off on opening Arctic Frost. Their signatures on a document authorizing a federal investigation into virtually the entirety of the opposing political party. Are you familiar with that?
Yes, Senator.
The operatives in Watergate hid their names. They were embarrassed to be part of weaponizing government. Here, the top leadership of the Department of Justice flaunted their abuse of power. Mr. Epstein, when power at the top gives permission, allies below move quickly.
That Watergate comparison is not accidental. It is designed to instantly put this in the category of historic political abuse. Now, viewers should notice the difference between allegation and proof here. The senator is making a strong argument that senior approval created permission for lower-level action. The witness agrees with the broader political logic, but the real question is whether the documents prove coordination or whether they show a lawful investigation being aggressively interpreted. That distinction matters.
That's how Washington works, isn't it?
I think so, Senator, yes.
And Arctic Frost quickly grew beyond the Department of Justice. Are you familiar with the names Tim Heaphy, Jack Smith, and Thomas Wyndham?
Some of those names, yes. Certainly Jack Smith.
Heaphy led the January 6th committee investigation of President Trump. Smith prosecuted him as special counsel, and Wyndham was Smith's senior deputy. Does that sound right?
Yes.
And all three coordinated with Fani Willis, the Fulton County District Attorney who brought the Georgia RICO case against President Trump, sharing witnesses, sharing documents, helping to prepare her witness interviews. Is that right?
Yes.
And when it was all over, these three men founded a law firm together. Is that right?
It appears so.
Washington has a lot of revolving doors, but this one spun from prosecution to profit. But you need not take my word for it.
Here comes the dramatic pivot. Follow the money. That phrase works because it shifts the story from legal theory to motive. The senator is suggesting that political investigations, professional networks, and later career benefits may be connected. To be clear, a revolving door is not automatically illegal, but politically, it looks terrible when prosecutors or investigators later appear to benefit from the same environment they helped shape. So the viewer's question becomes, is this corruption, bad optics, or just Washington doing what Washington always does?
Follow the money. Nathan Wade, Fani Willis's special prosecutor and her romantic partner, billed Georgia taxpayers $20,000 for 6 federal coordination meetings in 2022 alone. 2 with the White House, 3 with the January 6th committee, 1 on that same day that Jack Smith was appointed special counsel. This was a coordinated, organized operation by the Biden White House, the Biden Justice Department, and the Democrat Party to try to destroy their political opposition because they were terrified that the voters would do what they did, which is in November 2024, re-elect President Donald Trump. And this was the single greatest assault on democracy our nation has ever seen. Our Democrat friends are not shy about saying they're defending democracy, except when it comes to actually letting people vote. And they're willing to use all political power to stop people from voting. You know, Nathan Wade, under oath, he was asked about every one of those meetings. Wade said, "I don't remember." Anyone have a guess for how many times? 58 times. Wade's answer about those meetings was, "I don't remember. I don't remember. I don't remember." Mr. Epstein, when a prosecutor can't remember something 58 times, what does that tell you?
This is one of the strongest audience retention moments in the clip because 58 times is easy to understand, easy to repeat, and politically explosive. Now, memory lapses can happen in testimony, especially around dates and meetings, but when a public official repeatedly says, "I don't remember" about meetings tied to a major prosecution, it creates a credibility problem. The witness goes further and says the inference is that he is not telling the truth. That is not a small accusation. It is a direct attack on the reliability of the testimony.
I think the inference is that he's not telling the truth.
I think that is a very fair inference. In your judgment, should the architects of this scheme face criminal prosecution?
I certainly think there is a number of bases to investigate the activities that occurred.
And what bases come to mind?
I think the way in which there was ignoring the proper constitutional appointment of Jack Smith, the evidence of potential bias amongst some FBI agents in the Washington field office, the ways in which there was coordination with the White House counsel's office in ways that I think was inconsistent with the proper interpretation of the Presidential Records Act, and gave no ability for, at the time, former President Trump to assert constitutional privileges, the way in which the record shows that the National Archivist was clearly biased and made referrals to the FBI that were likely unauthorized, doing it through his Inspector General. And I think the evidence that this committee has shown shows that there was unfortunate coordination as for partisan motivation, and these documents shock the conscience.
Weaponizing the Department of Justice for partisan ends to subvert democracy and try and...
Now the hearing changes shape. Up to this point, the focus has been on systems: DOJ approval, coordination, prosecutors, documents, and subpoenas. But bringing in Mr. Clark turns the argument into a human impact story. That is powerful because viewers respond differently when abstract government power becomes a pre-dawn raid, legal fees, professional consequences, and years of proceedings. The political message is clear. This was not just paperwork, it allegedly changed people's lives.
Steal an election. Finally, Mr. Clark, you're here today because you have faced this subversion of justice, not as a statistic, but as a target. You were a partner at Kirkland & Ellis, spent nearly 30 years as a lawyer, is that right?
That's correct.
Your role in the events at issue, you drafted a memo raising election concerns. That memo was never sent. It was never enacted. DOJ leadership rejected it. Is that right?
That's correct.
And the results were stunning. In response to your writing a memo, there was a pre-dawn raid on your home with 12 agents who ransacked your home for 3.5 hours. Is that right?
That's also correct, and they took computers that had nothing to do with my legal work.
Georgia indictment, arrest, booking. Is all that correct?
Yes.
3 years of concurrent bar proceedings, federal scrutiny and litigation, hundreds of thousands in legal fees. Is that right?
Millions in legal fees, 5 going on 6 years of legal proceedings in the bar.
And last July, D.C. recommended your disbarment, your 29-year law license potentially gone for writing a memo in the Department of Justice. Is that right?
Yes, for writing a privileged memo that was leaked by my political opponents.
Every Democrat involved in this process should be ashamed of the weaponization and the persecution that is occurring.
Thank you for calling this hearing on this so-called investigation, which is an absolute mockery of the term. All the investigation was an attempt to browbeat ordinary citizens out of their constitutional rights and expressions of their constitutional right, including, of course, the First Amendment. It was an attempt to spy on members of Congress, including myself, who had our phones tapped. It's an absolute outrage.
In the United States, politics is a dynamic and often deeply divided landscape. Power shifts between two major parties, shaping policies on the economy, healthcare, immigration, and global leadership. Elections, whether for president or Congress, draw intense public attention, reflecting the voices and values of millions. While debates can be heated, they are a cornerstone of democracy, where differing ideas compete to define the nation's future. At its core, U.S., politics is a constant balancing act between tradition, change, and the will of the people.
That I hope will never happen again in American history. But I want to talk about another outrage today, if I could, that is very much in process, and that is the attempt by the American left to destroy the independence of the United States Supreme Court. We've had out of this court just in the last few days another series of leaks. I'm holding up here a page, a printout, this time the private papers of the justices. You might remember just a few years ago, somebody leaked an unpublished internal draft opinion for the first time in the history of the Supreme Court. Leaked it in an attempt to derail, it was the Dobbs decision, in an attempt to derail an opinion of the court. Now we have from the justices' personal private papers that by law belong to them. We have multiple leaks from February, from January of 2016, leaked to the press. Why? For the sin of the court's supposed failure to address the global climate crisis. That's right, ladies and gentlemen. That's what the New York Times tells us. The court has not managed the global climate crisis properly, and therefore, whomever it is at the Supreme Court who wants to destroy the independence of that body is now leaking the justices' own private papers. This is part of a coordinated attack on this institution that has gone on now for years. And the point of it is to destroy the independence of the Supreme Court, to browbeat that court into doing what the left in this country wants, and to hold up a clear threat to the court that if they don't, they will be packed with new justices, they will be personally threatened, their papers will be leaked, their security will be threatened, and in short, the left will do everything they can to destroy the court as an institution. I've worked at that court. I have litigated at that court as a private lawyer and as the Attorney General of the state of Missouri. And I can tell you,
this section is all about institutional legitimacy. Hawley is arguing that leaks, protests, court-packing threats, and public pressure are not isolated events, but part of one broader campaign. That is a serious claim, and viewers should separate two things. Criticism of the court is protected political speech, but attempts to intimidate justices or compromise confidential deliberations raise a very different concern. So here is the key question. Where is the line between democratic accountability and institutional intimidation?
what is happening now is absolutely a coordinated effort to destroy the court, and it has been years in the making. Years in the making. It goes all the way back to when President Obama stood in the well of the House of Representatives at the podium there and to the face of the justices browbeat and criticized them personally for a decision he didn't like. I've heard a lot of fussing from the other side of the aisle. They don't like how President Trump is critical of the court. Really? I don't remember a word when Barack Obama stood and looked at the justices and personally attacked them at a State of the Union address. But that was just the merest beginning. We have had since then an assassination attempt on the life of a justice, Brett Kavanaugh. We have had the current minority leader of the Senate go to the floor, to the steps rather of the Supreme Court, Chuck Schumer, go to the steps of the court and threaten the justices by name. By name. We've had a coordinated leak from within the court meant to derail the Dobbs opinion and to destroy it. We have had dark money groups, left-wing dark money groups, funding illegal protests at the justices' homes after an assassination attempt on the justices that the Biden Justice Department and FBI refused to stop, despite the fact they were illegal. For months, these illegal protests meant to threaten the security of the justices went on. Months and months and months, and the Biden Justice Department couldn't lift a finger. And I don't remember hardly a peep from the other side of the aisle. Oh no, this is a deliberate attempt to tell the court, do what we want you to do or we will destroy you. And this is just the latest attempt. I don't know what's going to be left. I mean, if the justices' private papers can be leaked, I'll give the Times credit. They're at least honest. They say they talked to, at least in addition to getting the private papers, 10 different individuals who were formerly employed at the court, who were familiar with deliberations over pivotal emergency orders and spoke on condition of anonymity. Why? Because, and I quote, confidentiality was a condition of their employment. In other words, multiple people from within the court who were delighted to violate their own employment agreements in order to put the private deliberations of the justices into view with the sole purpose of trying to destroy this institution's independence. I happen to believe in our system of government. I believe the three branches were designed for a reason. I believe the independence of the Supreme Court is vital. And I believe if you don't like decisions of that court, and there are plenty I disagree with, plenty, from Citizens United to many, many more, but you do not address those differences of opinion by trying to destroy the institutional legitimacy and independence of the court. And that is exactly what the American left is trying to do in a coordinated fashion. And I'll end with this, Mr. Chairman. We need to follow the money. Those protests at the justice's home that were designed to threaten their safety were funded by somebody. They were funded. I want to know who funded them. I want to know where the money from this pressure campaign, this multi-year pressure campaign, is coming from. We need to have hearings in this committee to unveil the sources of this.
Now the hearing moves from outrage to remedy. That matters because political hearings can easily become pure theater, but the real test is whether lawmakers propose specific reforms. Here the focus shifts to subpoenas, non-disclosure orders, congressional phone records, and the separation of powers. This is where the story becomes more technical, but also more important. If investigators can secretly access lawmakers' records without proper safeguards, what does that mean for oversight, speech, debate, and political independence?
Funding of this campaign and of this attempt to undermine our system of government. It is a clear and present danger to the operation of our Constitution, Mr. President.
Whether it be by an FBI agent who repeatedly engaged in political partisanship and violated the FBI's no self-approval rule, it's mass targeting of nearly 100 Republican groups, including Turning Point USA, the Republican Attorneys General Association, the America First Policy Institute, and the Republican National Committee. Or, of course, the decision to subpoena the phone call records of multiple members of Congress, including members of the Senate Judiciary Committee. Beyond that, I have concerns about evidence suggesting coordination between the Biden administration and clearly partisan prosecutors in Manhattan or Fulton County, Georgia, in pursuit of Trump-related investigations. We even have people that campaigned on taking him down. I mean, it's absolutely ridiculous. All in all, it paints a picture of criminal investigations that evolved into indiscriminate dragnet and targeted and harassed hundreds of entities, individuals, members of Congress that were all on the political right. It's highly concerning with respect to the law, the separation of powers, and Americans' faith in a system that depends on the blind administration of justice. I'm glad this committee has engaged in public oversight to learn more about what occurred and the steps that can be taken to prevent this from happening moving forward. Mr. Epstein, I have a question for you. There have been a lot of discussion regarding Jack Smith. We've heard it here today, and his team's use of non-disclosure orders throughout the course of the Arctic Frost investigation. This includes when such orders were sought and granted to accompany subpoenas related to the toll records of multiple members of this body. Many have argued those NDOs likely violated existing federal law and prohibited the use of NDOs on subpoenas involving Senate devices. The fact that at least one telecom provider, AT&T, refused to comply with that subpoena and the Smith team didn't push back is evidence that they probably knew that their requests were illegal in the first place. What is your view on that issue, and are there additional steps that we need to take to reform existing law or create new ones to better protect all Americans from NDOs being used in a politicized or an improper manner?
Yeah, thank you, Senator. I mean, clearly, as a matter of law, there needs to be consultation with the Senate before phone providers provide any of those records. Obviously, that's rooted in speech or debate, which has direct constitutional text. You can't force senators to speak or members of the House to speak without their consent. I would also say that as another statutory matter under Title IV USC 2118, congressional records are preserved and transferred in Congress's discretion to the National Archives. If there was interest in getting that kind of information, the more constitutionally appropriate mechanism would have been for the Smith team to get as many relevant records from the archives. If they're not preserved by, if they're not transferred rather by the Senate, again, that revolves back to speech or debate and whether the Senate consents to those things and whether the telecom providers have received that consent.
Well, Mr. Epstein, follow up on that. One of the principal concerns that people have brought up with Arctic Frost investigation and related state-level investigations is they tried to criminalize conduct that wasn't actually illegal. It is not illegal for someone to say that there may be fraud present. It is not illegal to question, what happened and how it happened and try to figure out a pathway moving forward. But yet we saw time and time again Mr. Smith focus on that and try to make that conduct illegal. No American wants to live in a world where you say, show me the man and I will show you the crime. So outside of conducting public oversight and the things that you have mentioned to ensure public accountability, what steps do you think that we can take or should consider to make sure that we don't fall into that same trap in the same way that some of those individuals involved with Arctic Frost and related investigations appeared to?
Yeah, I think one thing is to make clear as a statutory matter that the way in which Jack Smith was appointed was invalid, and to specify as much as possible into statutes what appropriate appointments look like. I also think that, when I think about the Bragg prosecution and Judge Merchan, that was a case where they were interpreting federal election law, which is totally inappropriate for them. And primary jurisdiction, something that I teach in administrative law, clearly laid with the FEC. And I think that there are multiple opportunities for clear statutes about primary jurisdiction to prevent the states from going on roving political investigations that they don't have jurisdiction for. But again, there's also the power of oversight. There's still questions that Congress can ask, and it can ask these states. It could ask these prosecutorial offices. If a group like America First Legal can use FOIA to get documents, certainly the Congress can conduct oversight.
This hearing gives viewers three major takeaways. First, Republican senators are framing Arctic Frost as a politically motivated investigation that expanded across federal, state, and institutional lines. Second, the witnesses and senators focus heavily on process, authorization, subpoenas, coordination, privilege, and accountability. Third, the broader message is about public trust. whether voters believe justice is being applied blindly or politically. The strongest moments were the 58 times memory exchange, the human impact testimony, and the debate over congressional phone records. Was this a strong oversight hearing, or did it leave too many claims still needing proof? If you found this political breakdown as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real-life political commentary and analysis.